Senate Study Bill 3171.
Thank you, Mr. Chair. Your subcommittee on Senate Study Bill 3171, consisting of myself, Senator Garrett, and Senator Hogue, have met and recommend passage. Senator Hogue has withheld his signature.
All right, you're in order for opening comments.
Thank you, Mr. Chair. I'd like to start with a brief explanation of what the Religious Freedom Restoration Act actually is and how it is that it became written the way that it is. The reason we have a Religious Freedom Restoration Act, after 199 to 200 years of a very consistent method of interpreting the First Amendment, the free exercise of religion, the United States Supreme Court ruled that strict scrutiny would be applied only if the challenged government action was intended to burden religion. And if the burden was unintentional for all practical purposes, the government will win every time. This was the very first time in our country's history that a decision by the court reduced religious freedom. Congress quickly set about reversing the effect of this decision, and in 1993, they had the federal RFRA written. It passed Congress almost unanimously. There was only 3 dissenting votes, and it was signed into law by President Clinton. He, at the signing of the bill, explained the bill in this way. What this law basically says is that the government should be held to a very high level of proof before it interferes with someone's free exercise of religion. This judgment is shared by the people of the United States as well as by the Congress. We believe strongly that we can never be too vigilant in this work. Then, in 1997, the Supreme Court ruled that the federal RFRA applied only to federal laws. And since that time, 21 states have worked at passing their own state Religious Freedom Restoration Act. In December of 2016, Representative Sandy Salmon and myself met with the Attorney General Miller to see if we could draft a RFRA that was appropriate for the Iowa State Constitution. We met with General Miller, his chief deputy, and the Solicitor General, along with a couple of other lawyers, to see what kind of ideas we could come up with. We presented our first draft to General Miller, and he said, oh, this really doesn't fit that well with the Iowa Constitution. So we went back to the drawing board and came up with another draft. When we presented this to Attorney General Miller, he declared, perfect. This mirrors the federal Religious Freedom Restoration Act and also reflects the spirit of Senator Ted Kennedy. We circulated this proposed language among many different industries and associations, some of which are represented here. And most of them received it quite well. But there were some that were worried that this might allow discrimination. So I spoke with General Miller about this, and his response was very quick and sure. This bill does not discriminate. It gives equal access to all people. Everyone is treated fairly. That is the end of my opening remarks.
Thank you. Are there comments or questions on the bill? Senator Hogue, you're recognized.
Thank you, Mr. Chair. I want to begin, since Attorney General Miller has been invoked here, and say that I think it is not proper for a senator to convey what the Attorney General allegedly has said or done or thinks on a bill or not done when the Attorney General is not registered on that bill. As you know, Senator Guth, the Attorney General often takes a position on legislation. He has not done so on this legislation, and according to his staff, Attorney General Miller recognizes that he worked with you and others on the proposed legislation that it was, so that it would be similar to the federal law enacted by Congress and sponsored by Senator Kennedy. But he is not taking a position on this legislation, and his involvement, I think you improperly portray as an endorsement of the bill rather than a commentary about trying to make it drafted in a way that wasn't too goofy, Senator Guth. Okay. Now, this bill is really bad. And I don't think in my 16 years I've ever seen so many business organizations register against legislation. And it's bad, and they know it's bad because this bill has the appearance of trying to allow discrimination against Iowans, and in particular LGBTQ Iowans. And the business community has said, we don't want to get involved in that controversy. That's not good for our businesses. We are trying to recruit workforce. And you heard that at the subcommittee, Senator Guth and Senator Garrett. You heard that. But for the people who were not there, this bill is opposed by the Iowa Chamber Alliance, the Association of Business and Industry, Principal Financial, Microsoft, Apple, Amazon, Google, Facebook, Wellmark, the Greater Des Moines Partnership, the Ames Chamber of Commerce, Cedar Rapids Metro Economic Alliance, Iowa City Area Chamber of Commerce, Federation of Iowa Insurers, the Travel Federation, the Hale Group, and a number of other nonprofit organizations who also similarly believe that this legislation is wrong. This bill should be rejected because it is bad for business. It jeopardizes worker recruitment, it jeopardizes convention recruitment, and it jeopardizes events that have been planned in the upcoming 18 months where they have said that if this legislation is passed, those events will leave the state, including the NCAA tournament in 2019. Now, in addition to being wrong and bad for business, I also want to point out that Iowa's civil rights law already has an exemption for bona fide religious institutions. 216.7 subsection 2A. And I brought the code book so that you could all hear it. This section shall not apply. This is the section on accommodations or services. This section shall not apply to any bona fide religious institution with respect to any qualifications the institution may impose based on religion, sexual orientation, or gender identity when such qualifications are related to a bona fide religious purpose. So the concern that is motivating, I believe, your legislation has already been addressed. But I want to make a point that the problem with this bill is actually much broader than even that. Senator Guth, would you yield to a question?
Certainly.
I know you have indicated that you're concerned about a 1990 Supreme Court case.
Correct.
Do you know what that Supreme Court case was about?
I do have the information in here. It was about an employer and employee deal.
Right. It was about
versus
Oregon. Right. It was about employment compensation for an employee who had been fired for using peyote, which that employee believed was required as part of his religious tradition. And he was fired for using peyote, which is, I didn't know this, but I researched it, and it's a hallucinogen that's apparently extracted from the cactus plant. Did you know that?
Yes, I did.
Okay. Now, do you know who wrote the opinion saying that the application of the law prohibiting controlled substances to include peyote, that was not infringement on religious freedom? Do you know who wrote that opinion?
No, sir, I don't.
Okay. Well, that was Chief Justice Scalia, or Justice Scalia wrote that. It was a 5-4 decision. Scalia was joined by Rehnquist, White. Gotta go to my notes here. Gotta go to my notes. Just a second. Scalia, Rehnquist, White, Stevens, and Kennedy. Those were the 5-member majority who said that this isn't a free exercise issue. Now, Senator Guth, there was some discussion in the subcommittee that there really haven't been many cases. Do you remember that? I think one of the people said there haven't been many cases.
I've been, there has been, I believe, 4 that I've been made aware of.
Okay. Well, in 2006, there was a case brought by Bush's Attorney General Gonzales to try to reverse a New Mexico case. You're familiar with the Gonzales case?
You might as well refresh me.
Okay.
I don't have all the notes.
Well, thank you for yielding, Senator Guth. I appreciate that. What the Gonzales case said was that under the federal law, that a Brazilian sect, a religious sect that had its origins in Brazil, had the right to use hallucinogens as part of their religious ceremony, despite that under federal law, the Controlled Substance Act, those hallucinogens would be banned, right? The federal law says you can't use this hallucinogen, but in 2006, despite the efforts of George W. Bush as Attorney General, the Supreme Court said under the 1993 RFRA law, a state cannot stop, the federal government cannot stop a religious sect from using hallucinogens. That's the Gonzales case, and I encourage people as they move forward, if this bill moves forward, to think about it. Because basically what you're saying is if you vote for this, you're voting for religious exemptions to Iowa's Controlled Substances Law. And maybe that's what you intend to do. I don't think it's what you intend to do. Mr. Chair, there's more. Why did Justice Scalia say that this bill was wrong? And I think the committee needs to hear why that is the case. Because it's powerful language, and I want you to know about it. I know you invoked somehow that they'd reversed a century of precedent. Two, okay. Well, here's what Justice Scalia said about that. We have never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting conduct that the state is free to regulate. On the contrary, the record of more than a century of our free exercise jurisprudence contradicts that proposition. Conscientious scruples have not, in the course of the long struggle for religious toleration, relieved the individual from obedience to a general law not aimed at the promotion or restriction of religious beliefs. The mere possession of religious convictions, which contradict the relevant concerns of a political society, does not relieve the citizen from the discharge of political responsibilities. Laws, we have said, are made for the government of actions, and while they cannot interfere with mere religious beliefs and opinions, they may with practices. And I excuse the archaic language that Justice Scalia was citing, but he said, can a man excuse his practices to the contrary because of his religious belief? To permit this would be to make the professed doctrines of religious belief superior to the law of the land, and in effect to permit every citizen to become a law unto himself. That's what Justice Scalia said, because he's worried about what the exemptions are going to be. And he goes into great detail, Mr. Chair and members of the committee, to explain why the compelling interest test is not very reassuring on that. And I want to share a couple of comments. So there is, in the language of the bill, there's a compelling interest test. It's modeled after the 93 law. The courts have already said you might have some interest in restricting hallucinogens in religious ceremonies, but that's not a compelling interest. And this is what Justice Scalia said about it in 1990. If compelling interest really means what it says, and watering it down here would subvert its rigor in the other fields where it is applied, many laws will not meet the test. Any society adopting such a test would be courting anarchy, but the danger increases in direct proportion to the society's diversity of religious beliefs and its determination to coerce or suppress none of them. Precisely because we are a cosmopolitan nation made up of people of almost every conceivable religious preference, and precisely because we value and protect that religious divergence, we cannot afford the luxury of deeming presumptively invalid, as applied to the religious objector, every regulation of conduct that does not protect an interest of the highest order. The rule respondents favor would open the prospect of constitutionally required religious exemptions from civic obligations of almost every conceivable kind, ranging from compulsory military service, the payment of taxes, health and safety regulation, compulsory vaccination laws, drug laws, traffic laws, social welfare legislation such as minimum wage laws, child labor laws, environmental protection laws, and laws providing for equality of opportunity. And he cites cases for every one of those. Right? And what you're saying with this legislation, as Justice Scalia pointed out, is, well, we have these generally applicable laws, but now we're going to say a person's sincerely held religious beliefs trump that general law, whatever it is. So if you vote for this, you may be intending to say, we want to exempt people from civil rights legislation that involves gay and lesbian Iowans. That may be what you're trying to do here, but what you're doing is you're jeopardizing our tax laws, our health and safety laws, our vaccination laws, our drug laws. Supreme Court, green light for hallucinogens in religious ceremonies, if that's what you think your religion requires. Traffic laws, social welfare legislation, minimum wage laws, child labor laws, environmental protection laws, and, importantly, laws providing for equality of opportunity. We don't want to go this route as a state. We don't want to create religious exemptions from generally applicable laws, including our civil rights law. This would be a mistake. You got the list of businesses that are against it. You've got Justice Scalia explaining why it's not good, why it would not be a good thing to do. And I just think it'd be a real mistake for this legislature to go this route and really might give Iowa a black eye with businesses and workers across this country. So I urge you to vote no today. It just takes 6 votes to vote no. We can stop this legislation now. You know this doesn't have the votes to get off the floor. You know it. You've been talking to your colleagues. You only had 19 co-sponsors on the bill. You don't have 26 votes. Stop this thing now. Don't make every business in the community scramble to try to make sure they're going to have their conventions here and their other things here. Make sure they feel free to keep recruiting the workers that want to come here, the people who love Iowa because of its great civil rights tradition. Don't do it. Thank you, Mr. Chair. I hope you vote no.
Thank you. We're almost out of time. I don't know, we've got at least 2 more senators who want to speak, and we want to let them speak. If we can't wrap up fairly soon, and then hopefully the powers that be will give us a little bit of leeway, but we may have to come back later this afternoon. Yes. So just be forewarned, Senator Cornbach.
Well, thank you, Mr. Chair. I, too, am in opposition to this bill. I think Senator Hogue made an excellent case. I'm not the attorney that he is. I can't cite a lot of case law. But I am 67 years old, and there are some benefits for advancing age. Bifocals, arthritis, and hearing aids are not among them, but I do go back a ways. In particular, I remember the debates over the great civil rights law of 1964, probably the most important piece of federal legislation in the history of our whole nation. And back during that time, there were people who would speak up in opposition to that law, who would claim, on the basis of religious views, to defend segregation, racial segregation. The argument went something along the line, said, well, if God had wanted blacks and whites to live together, he would have created them on the same continent. Well, God did. We're all Africans if you go back far enough, but never mind. There was a sincerely held religious belief that someone's God dictated segregation and justified that. I am seriously concerned that someone who shares those views even today could use those views as a justification for denying public accommodations, denying a seat at a lunch counter, denying a cab ride, denying a hotel room, denying employment to people of a different race. That they could use the religious protection, so-called, in this bill to generate discrimination of the type that we hope that had disappeared half a century ago. It's not limited to racial segregation. I'm not an expert on world religions, but I am aware that there are a number of the ancient and more traditional religions, some not so ancient, that require men and women to be segregated in worship services, and that further have some views about the appropriate conservative dress for women and the appropriate roles that women can and cannot play in society. Can we countenance this bill allowing a merchant, allowing a restaurant to segregate the seating by gender, or to deny service to a woman who is not wearing a headscarf? Is that the direction that we want to go? What about corporal punishment? There are some people they should discipline their children physically if necessary. Probably the most extreme case, and again, I'm not a biblical scholar, but I seem to recall that God commanded Abraham to kill his own son as a test of his faith. Now, in the end, God let Abraham off the hook. But so suppose we had a modern-day Abraham who had a similar sort of view, who believed some voice from somewhere, some divine commandment that they should kill or maim their own child. I would hate to see that person who acted on that belief get off from the legal consequences because of a defense based on this bill. Religion versus religion. There's a lot of antagonism between different religions, and I'm afraid that in this country that has only been incensed in the last couple of years. I think we all are aware of some of the terminology used by members of some religions to describe members of other religions. Heathen is probably the most polite term. I won't repeat any of the other terms that I've heard, but we've all heard anti-Semites and others spew forth their hatred. Are we to allow religious differences to allow the denial of public accommodations, the denial of hiring and promotion, the denial of admission to schools and training programs? This legislation potentially guts our civil rights law. We have a very strong civil rights law in this state. I am proud in 2007 to have added to that protection for lesbian and gay brothers and sisters, and I do not want to see those protections undermined. There is, as Senator Hogue pointed out, an exemption in our law for practices within a bona fide religious institution. But what we're talking about here is when people take their religious views out into the marketplace and engage in ordinary commerce. I believe that they should follow the civil rights laws, and that if their religious views are at odds with the requirements of equal opportunity in the marketplace, then perhaps they should find a different line of work. We're not messing with their religious views, but we are requiring them to behave in the commercial sector in an appropriate, fair-minded manner. Thank you, Mr. Chair.
Thank you, and Senator McCoy, you're in order.
Thank you, Mr. Chair. I think that we're all in agreement that religious freedom is one of the fundamental rights secured by our secured by our Constitution. And one of the challenges that that Indiana saw after passing a similar law is that they had a massive impact on their economy. In fact, after that law went into effect, 75% of the voters, and it was an equal number of Democrats, Independents, and Republicans, were surveyed, and they say that the religious liberty fight was bad for the Indiana economy. 47% of the voters in Indiana thought that the state had moved from a right track to a wrong track, and that was a massive swing. And the business community in general said that this had the impact on them of a natural disaster damaging their economy as a result of this law going into effect.
My understanding is that we currently have housing laws that would forbid that. If he was going to be persistent in that, he would have to go to court. But there is perhaps, I can't tell how the judge would rule in a situation like that. You know the court that we have here in Iowa and the tendency that, or the leanings that they have, so that would be decided in court. Currently, I know some of those decisions are made by one person. There is no recourse to that. I had one situation that was explained to me by a friend of mine that is a lawyer, that he was engaged in a situation like that. It happened to be a single mom came to look at an apartment and went through it, and she was actually employed by the Civil Rights Commission. But of course, that was undercover. And she went, and after looking at the apartment, she asked, "So how much is the utilities going to cost up here?" And the guy that owned it said, "Oh, I'm not really sure. You probably have to look it up and call the utility company. You can certainly do that." And he said, "Oh, by the way, my wife knows." And he called her up on the cell phone. And she said, "Oh, I don't know either. You're going to have to call the utility company." Later on, there was another woman who was Hispanic in the same situation that used the same script. There was a few weeks in between. And went through the same situation. And she said, "So what's the utilities going to cost?" He says, "I'm not sure. You're going to have to call downtown and open them up and see what it is." But he never offered to call his wife because he knew that she didn't know the answer. Because he didn't offer to call his wife, the Civil Rights Commission brought a suit against that person to say that they did not bring suit. They were close to bringing suit. That's why the employer was employed. It's because there is no recourse to a charge in the Iowa Civil Rights Commission.
It's not true. That's not true, sir.
There is actually, according to the same lawyer, if you would do that, you have to no longer innocent until proven guilty. You are guilty until proven innocent, and it is very difficult to fight that sort of thing.
Well, I would encourage you to acquaint yourself with the Civil Rights Code as it relates to housing, because there's a hearing and there's opportunity for people to present facts, and there's an entire process before a person could be. But the final thing that I wanted to understand is what burdens today contribute to the necessity for this legislation that people have today that you're hearing about. How are people unable? I mean, because the standard's pretty broad. Exercise of religion means the practice or observance of religion, and basically under this bill, we're saying that the burden to exercise of religion would be would be required. In other words, you would have to demonstrate what burdens would why are we needing this legislation? Help me understand. Yes.
I think it's important that Iowans are able to live and work every day according to their beliefs. That's one of the basic things that this country was founded on. When we look at those that came to the United States or to America at that time from Europe, they left because they did not have that right. And I think that we are going in that same direction right now. We need to make sure that we don't chill the whole aspect of being able to practice your own beliefs.
How would that, give me one modern day example of how that is happening?
In all of the churches that I visited across my district, there is a fear that government is going to come in and start dictating what they can and cannot preach. This is a very widespread fear in the culture, something that goes beyond a little incident here and a little incident there. It's the sort of thing that suppresses religion in its entirety across the state.
Okay, but is that a fear or is that a reality?
I would call it a reality.
Do we have any example of where religious churches were told they could not preach from the pulpit on any subject?
Well, we have that attempted in Houston. It was not in Iowa, it was in Houston, where they had the sermons were subpoenaed before they could be preached by the city council. That's one of the things that this would try to prevent. I think it was 2 years ago.
Okay, so I'm not familiar with that, but I'm looking for an Iowa example of something that
Okay, how about the University of Iowa, when they decided that they had to ban a campus group because that campus group mission statement did not conform with their policy.
I can't imagine. What was the group?
Blank was the name of it. It's let's see if I can remember what the acronym stands for. Business Leaders in Christ. And they just had a lawsuit here a couple weeks ago.
And how did that turn out? We're still waiting for a decision.
My understanding is, I don't know all the details, my understanding is that the university has filed slap on campus.
So once again, the court upheld the rights of this group to be on the university campus.
Actually, I better not get into the legal parts of it. I don't think that was the actual reason that they got the campus. I believe it was something else.
Okay. Well, Senator Duke, thank you for yielding, and senators, thank you for thoughtful discussion. Again, I think that this creates a very broad standard that could imply that any individual could legally discriminate against another for any reason that happened to offend with religious beliefs. And I think that is a very bad message to send to Iowans and a very bad road to go down. In addition, I think that we've seen the failure of these laws. We saw what happened in Indiana. We've seen where our business community has come down with these issues. And I really think that in all of your examples, what you led me to believe is in order for a person to get that prescription for recreational pills, or in order for that person to be able to rent that apartment, or for a person to be able to stay at that hotel, or for a person to eat at that restaurant, they have to bring a suit. And I just think that that is a very high standard for people that are discriminated against to have to meet. I think this is misguided, and I think a very poorly crafted piece of legislation to do something that, that in my opinion, allows for legal discrimination. So I was opposing this, and I hope everyone else will as well.
Thank you. Senator Booth, your word for closing comments.
Thank you. One of the things that's frequently talked about is the poor effect that this would have on our state's economy. And I believe Senator Hogue mentioned here in subcommittee that Iowa has the 49th slowest growing economy in the state at this point, which would mean that all of the states that currently have a RFRA are ahead of us. If we look at the 21 states that have adopted RFRAs, according to statistics from the United States Department of Commerce, in the year following the RFRA, those states' gross domestic product grew by an average of 4.1%, which we'd certainly appreciate here in Iowa this year. Several states had a gross domestic product in excess of 6%, some as much as 8.8%. And tourism and the coming of conventions and things like that was also discussed. According to the Department of Commerce data, every state that has adopted a RFRA, the state of arts, entertainment, recreation, accommodation, and food service industries grew the following year after RFRA's enactment. The average GDP growth rate in tourism and entertainment in these industries was 4.8%, with some states exceeding 8%. Actually, Arizona was 11.7%, and Illinois was 10.1%. Talking about the convention business, and especially just after the tourism board in Indianapolis said this was going to be the worst year that they've ever had, they announced that the city posted new records for sales conventions in 2015, securing an estimated $1 billion in economic impact. The city booked 904,717 future convention hotel room nights, and this broke the previous year's record of 880,552 by over 24,000 nights. Simply put, Indianapolis has never had a better year than after they passed their RFRA. There's a lot of things that we can talk about this, whether it's the economy or the freedom of speech, but I think the important thing for us to remember, I believe it was Senator Hogue, or no, I think it was Senator Talbach that mentioned that that the limits we have on religion now does not apply to an institution. But what is important about this bill is that it protects the rights of citizens from the intrusion of the government on our diversity of thought. If we must all think the same way, if we can only act in the way that the government condones, we have no way to meet together corporately and pursue truth. And as I look at the senators around this table, I see a lot of people that are concerned about truth. We come at it from different angles, but we all want the truth. And we shouldn't be forbidding someone else's ability to pursue that truth. Mr. Chairman, I realize that it's getting a little late here, so I guess I would, at this point, just like to move the bill. Thank you.
Thank you. Record's been called for. Secretary will call the roll.
Senator Garrett.
Aye.
Senator Lofgren.
Aye.
Senator Hogue.
No.
Senator Allen.
No.
Senator Sheldron.
Aye.
Senator Green.
Aye.
Senator Guth.
Aye.
Senator Cranbrink.
Yes.
Senator McCoy.
No.
Senator Kornbach.
No.
Senator Siegevart.
Aye.
7 ayes, 4 nays.
All right, the bill passes and is eligible for debate on the floor. There's nothing further. The meeting is adjourned. We do perhaps have a